Welcome to the Business SOS podcast. This is Rich Sierra, president of the Florida Small Business Legal Center. This is episode 104 of our series. Very excited that we surpassed the 100 mark, and now we're in episode 104, and we continue to episode 200. Thank you for listening and continuing the journey with me. Today, I want to talk about mistakes. The podcast is really based on my book, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them, which is available in Amazon, Barnes & Noble, and also you can ask for in your local bookstore. But the reason I talk about mistakes is my purpose is to give you those tips for you to avoid in your business journey. And the mistakes continue to happen, and I sometimes talk about things that happened perhaps the last few weeks in my practice and share with you so you don't fall in the same trap. Some of these mistakes can be fatal. They can be the end of your business. After you spend all this money investing, all the hard work, sweat, blood, and tears, and to find out that you made an avoidable mistake that could be avoided if you did not know about it. So that's why I share this with you. So today I'm going to talk about 5 shocking legal mistakes that could destroy your business. So let's get started. The first one is operating without a written agreement. If you have a partner and if you listen to me, you have heard this before. If you have a partner and you're working, or partners, you should have a bylaws or an operating agreement or a partnership agreement. They all operate pretty much the same way. And I see in too many circumstances that business owners, because they know each other, they're friends, and they're familiar with each other, they feel because they have a friendship, they do not need an operating agreement. And I beg to differ. In fact, having an operating agreement, having a partnership agreement, most likely will keep that friendship intact because conversations have taken place beforehand that would have discussed and would avoid situations in the future. And I'll give you an example. Okay, I deal with a lot of partnership disputes, and I've been doing this is my 21st year in practice. And when I get a call from a business owner says, my partner, I want to break the partnership, I want to sue him or sue her, and I ask what happened. Well, very common themes. The partner is utilizing the business funds for personal expenses. The partner is not paying the other partner his or her salary. The partner, in worse situations, have decided to lock the other partner out of the business completely. The partner is deciding to make a large investment in equipment or inventory, or the partner is firing employees without consulting the other partner. So it becomes a tremendous disruption in the business when one partner makes a major decision in the business that could affect everyone. So my next question to that is to the prospective client is like, do you have an agreement? Do you have a partnership agreement? Do you have anything, and how do you guys, what you agreed upon? No, we don't. Do you have any writing? No, we have some text messages. It's very common for me to get that answer. And ask why you decided not to have one. What happened? No, he said we didn't need one. We didn't want to spend money on lawyers. We have it all worked out. Apparently not. So for that reason, I do recommend a partnership agreement, and to have those conversations in advance. And I have offered to my listeners, whoever wants to send me an email at richsierra.com, for free, my operating agreement questionnaire, which is really a series of questions. That's the questions that I use when someone asks me, to prepare an operating agreement for the company or for partners. That's what I send out. And the reason I do it is like, if you don't get past the questions and you don't come up with an agreement on the questions that I ask you, which are not really that difficult, you're not going to be able to get through a partnership. It's just not going to happen. And I'll give you an example of these questions. Okay, what is the percentage of ownership on the company? Is it 50-50, 49-51, 60-40, whatever percentages are decided based on the investment, based on the sweat equity, it's good to put that in writing. Because on some occasions, you have people perceiving that they're 50-50 partners, but in reality, one partner perceives, no, because I invested the money and you did not, I actually own more of the company than you do. But that's something that should be put in writing. How much to invest in the company? What is going to be the investment of each partner? Is one partner going to put 50% of the working capital that's required to get the company started, the initial investment, and the other partner the other half? Or is it going to be a situation where one partner said, I'm going to be the investor, but you have the technical background to run this business, so he's going to put in the sweat equity, as we call it. Nothing wrong with that format. There's nothing wrong with having that framework. The problem is that when you don't have it in writing, it becomes an issue of not having an understanding of what the partners agreed to do. And I see that in some cases when people go into joint ventures or partnerships, say, for example, to flip homes, that one partner has the investment dollars to purchase those homes, and the other partner might be a general contractor who will fix that home, and then for the purposes of selling the home. So it's good to have that in writing, but that's just a fatal mistake that I see the many business owners make, and it is completely preventable and avoidable simply by having a written document. Another, within this mistake, I see having poorly written operating agreements or partnership agreements without the right provisions. An example, you can go on the web and you can buy some templated forms that's been available for a long time. Some of them have good boilerplate provisions. They're good starting point, but may not necessarily, it will not have the agreement that you agree with your partner, simply because there's no way the form will know that. Whoever created a template will know that. But it's a good starting point. So what happens, they download it from the web, they sign it, and here it is. And in some cases, I see blanks, I see the wrong state, the wrong dispute resolution, or a dispute resolution that is actually more expensive, that they would have opted out of a different one. An example of that, I see some of them that have AAA, American Arbitration Association clauses or other type of arbitration system as a dispute resolution. And when asked the question, so do you know what is the American Arbitration Association? They say, no, what is a private organization that specializes in dispute resolution? They provide arbitrators, they provide mediators. And they said, no, I never heard of them. And I said, why is this in this contract? Well, it was there. And I said, do you know how much it will cost you if you decide to, if you have to utilize this clause to resolve the issue? In some cases, by the time they send me the contract, we have to exercise that clause. I said, no, I never looked at it. So I sent the fee schedule. And in some cases, it's very expensive for the average business owner. Again, there's nothing wrong with opting for those clauses, as long as you know what it's going to cost you if you have to exercise them. What is wrong is integrating a clause into a contract that you do not understand. You know my rule, if you do not understand the contract, don't sign it. Just get a professional to help you understand the contract, and you decide for yourself whether or not you want to pursue it. There's no plan for the death of a partner, disability, or disputes. So this is, in terms of, that's mistake number one that I wanted to go over. If you have a partner, my recommendation is get it in writing. My recommendation is also to have a professional help you draft that document. Mistake number two, fatal mistake number 2, is the lack of understanding of the protections that a corporation provides to you, whether it's an LLC or a corporation or an Inc. And people call it S corp. S corp is simply a pass through. It's a tax designation. It has nothing to do with the piercing of the corporate veil, which is the topic of mistake number 2. And what is the corporate veil? If you're acting on behalf of the company and you're signing, say, you have vendor agreements, you buy inventory from your supplier, and for whatever reason you owe that supplier money. The company owes money to that supplier. The business is not doing well. The business goes under. And you got to dissolve the business. They sue the company. They can only collect from the company if the company has any assets. You, as the owner of the company, will now have individual liability, personal liability for corporate acts. That's what is the corporate veil. There are ways to pierce the corporate veil. That's a whole podcast in and of itself, but I want to give you some general guidelines here. The corporation cannot be used to commit fraud. So if there's an instant that fraud was committed, fraud is alleged to be committed utilizing the corporate structure, that is one way that, someone can pierce the corporate veil. So, and usually you have, very common when we file lawsuits against a company for misrepresentation or fraud and inducement, a fraud claim is included against the owner in order to pierce the corporate veil. But generally speaking here, if you have a corporate entity and you're strictly doing business on behalf of the entity, the individual is not liable for those corporate acts, financially liable for corporate acts. And again, there's some exceptions, and I'll just give you a quick one, which I think I've mentioned before. If you owe payroll taxes, if you owe overtime or unpaid wages, the corporate veil is not going to help you there. You can be personally responsible for that, but I'll talk about that later or a different segment. Another way that the corporate veil can be pierced is that if you sign a personal guarantee. That is, and I see the very common in lease agreements. People come to me and say, the business didn't do well. I got sued by the landlord for unpaid rent and for the balance of the rent. I said, I want to make sure that I'm not liable for that. I cannot go after my bank account or personal assets or my home. So I look at the lease, and I see there's a personal guarantee signed, included as part of the documents. In that particular case, you have waived your corporate veil protection because you have personally signed the document to guarantee the performance of the company. And in many cases, when I talk to clients, they do not know that they have a personal guarantee. Said, do you know that you signed a personal guarantee? It's an Exhibit B of the lease. This is an example. I said, no, I don't know I had one. And said, did anyone help you read this document? 9 out of 10 times the answer is no. So it's important that if you're going to sign something as important as a lease agreement, just get an attorney to help you. It might be worth a few $100s to do that. It'll give you peace of mind. And the topic of employees, so this will be mistake number 3. Misclassifying employees as independent contractors. And I think that the mistake is ignoring employee classification and wage laws. This is very important, and I think at some point I'm going to bring an attorney as a guest that specializes in wage and hour and overtime lawsuits. That is a specialty in and of itself. So I think I'll bring somebody in to serve as a guest and ask those questions. But you as the employer need to make sure that you classify employees correctly. And I hear this term very often when I talk to employees. Say, well, how many employees do we have? I have 5. They're 1099 employees, I hear. And I said, well, how does that work? Well, they work for me, but they told me just not to take taxes and pay them as a 1099 so they can take their own taxes, and they pay for them themselves, so I give them 1099s at the end of the year. Okay. That is a mistake. There's no such thing as a 1099 employee. They're either independent contractors or they're employees. They're not both. If you supervise the employee, and if you set the hours of that employee, and if you provide all the materials for the employee to work, you set the hours, you can dictate when or not they go on lunch breaks, they're going to go on lunch breaks, but you can dictate when they go to lunch breaks, whether or not they can have vacation time, when they have to report to work at what time, when they leave, they work at your office, they're working exclusively for you. That's an employee. So to pay that employee as an independent contractor, you're taking significant risks. And that includes failure to pay overtime wages, failure to withhold federal and state taxes, payroll taxes, failure to pay unemployment that you're supposed to pay with the state of Florida, and you're taking significant risks for saving a few $100s a paycheck. It is not worth it because you could be personally liable for those taxes. And usually what happens in this case is the following. So you have an employee that you're paying as a 1099 employee. You fire the employee, it's not working out, you fire that employee. Employee's disgruntled, he's unhappy. Then he talks to his friends or her friends, find out, listen, I got fired, and usually say he owes me money, I was not getting paid overtime, I was working all these hours. Somebody tell them, listen, you got to check with a lawyer because he might owe you overtime. So this employee goes to an attorney, goes online and says, I need an attorney. How do I collect my overtime wages? I guarantee you there will be an attorney ad that's showing up on Google, and now with the AI feature they have, Google will make recommendations of who to call. And the attorney will have the ads, free consultation, you don't pay anything, the attorney's fees will be collected for the employer. The employee makes a phone call and has that consultation. If the attorney determines that there's likely overtime wages not being paid, and that you did not withhold properly the payroll taxes and pay those payroll taxes, you will be the target of a potential lawsuit. Most likely you will be. And that's a federal lawsuit. You can have state lawsuit, but you also have a federal one. And the way it works with these types of lawsuits, especially when dealing with wage and hour or employee overtime collection of overtime, is that if you do not have the correct records, it is assumed the employee is correct. This is a pro-employee statute. And the way they negotiate these is that the employee's wages are paid, plus might be some penalties along the way, but the attorney's fees are separate. They're not together. So you end up paying 2 different payments, one to the employee and one to the attorney. And then the court has to approve the attorney's fees. So it's completely separate. So if you can have independent contractors, just be certain that they are independent contractors. And I went and did a podcast on that, employee classification. I'm probably going to do another one to do a refresher. But generally speaking, Independent contractor is that. And I'll give you an example. A graphic designer that's doing some work for you. It's not exclusive. Just one project for you, maybe a brochure, just a logo. And sends you bills, you pay it. That's the end of that. You don't supervise this graphic designer. You don't provide hours. You don't tell where the graphic designer can go on vacation. It's a one-time deal, or maybe a recurring type of assignment, but you have zero supervision over that individual, and that individual provides his or her own tools. Most likely it's an independent contractor. Okay, so I'm just going to keep that in mind. Mistake number 3, inadequate or missing contracts. And this is contract for your services we're talking here. And I'll give you another example. I work with people that sell different types of parts, whether it's aviation parts, people that provide design work as well, like home design work, people that manufacture custom furniture or custom kitchen furniture as well, closets, different types of businesses, especially doing this for 21 years now. It surprised me how many people I've encountered that when they call me and say, well, this customer has not paid for my services. Oh, there's a dispute about the services or whether or not the goods were delivered or prepared. And I say, can I look at the contract? Here's the contract. And then the contract lacks many provisions. It lacks about, first of all, it's not signed. It is important that if somebody's going to accept your services, your proposal, that you get a signed document. And a countersigned document is preferred, but at the very least signed by the customer, so the customer agreed to those terms. And you can have one document that gives you all the terms and conditions. You only change the services that you're going to provide. That's the way I design my contracts. So they can be reused. They can be updated, but they can be reused. So not having the proper provisions in your contract makes it difficult to enforce them, because then you have defenses. Then you have, well, that's not really what we meant. And I've seen situations in which the vendor provides his contract and then my client provides a different contract and they sign both. That becomes a litigation challenge, because then which contract is the one that we're operating under? So you cannot sign both contracts. Either you sign one or sign the other, but it's never a good idea to have two contracts that could say the same thing, but they have different terms. And then you have an issue of enforceability of the contract. Then you're trying to figure out which one is it. So in a case like that, call your attorney and ask him, listen, this is the situation, what should we do? And get that proper guidance. I've seen contracts, especially in some vendors require some type of non-compete agreements, and that's a no-no, especially if you're providing services. Or confidentiality agreements, which is fine, but has to be limited. So not only they're inadequate in some cases, but there's some clauses there that may not benefit you depending on what services you're providing. So it is important to know that. There's no jurisdiction on the contracts. Granted, the jurisdiction is where the services are rendered or where the payments will be paid to, but there's no dispute resolution as to that. And in some cases, many cases, there are no attorney's fees provision in the case you have to enforce the contract. So if you're going to be providing services or selling goods in a regular basis, other than a retail that you go to a store is different, or a restaurant, it is important to have the contract that you can enforce, that will not be difficult to enforce, and that an attorney can help you. But that's a mistake that by not having the proper contracts, you can lose a lot of money. Mistake number 5, overlooking key risk areas. And there are a number of them. I kind of combine these into one segment. And one of them is not having business insurance or adequate insurance. And it's important for you to know the type of insurance that you have. In your business journey, you will have disputes. It happens. Very seldom they rise to the level of a lawsuit, but sometimes they do. And I've had circumstances in which my clients get sued, and I said, do you have insurance? They say yes. And I said, I'll take a look at it, or I'll send a claim to the insurance company. And in some cases, the insurance companies deny the coverage because the coverage that was provided is not the circumstances that led to the lawsuit in the first place. And I'll give you an example. You might have, if you're leasing your location, unless you own the building or working from home, you probably have general liability insurance. The landlord requires it in the case somebody slips and fall, when somebody's going to visit your office or your place of business, or some incident happens, that there's a policy in place in the case somebody suffers some physical injury in your place of business, that insurance covers that particular lawsuit or individual for potential claims. The landlord will require that. And there's some misconception that because you have that insurance, that'll cover everything. And it is not the case. And so understanding what coverage you have becomes very important. And I do recommend, talking to a business broker, and at the very minimum, have professional liability insurance, depending what type of coverage, what type of business you're in. Obviously, general liability insurance. There's some of them that provide business interruption. Just get the guidance about what type of insurance they provide and which ones are necessary, which ones are, more discretionary depending on your budget. But understand what type of protection you have should something happen. But not having insurance certainly is a significant mistake. There's no succession or exit plan in your business. Depending on your business, what happens if you are incapacitated, what happens if, God forbid you die, and prematurely, what happens to your business? What is the succession plan? And if you recall, a few weeks ago, I had my friend and colleague, AJ Yolovsky. He was here, and we talked about succession planning. And if you haven't a chance to listen to that podcast, go back a few episodes and listen to it. It's very, very insightful. And he certainly can provide guidance in that subject. Or if you want to sell it as well. Having that understanding and what is your exit plan of the business, if you have one. Failing to comply with licenses and permits is very important to have your business tax receipt. It comply with any regulations that you have. And many businesses, unfortunately, do not. So it's important to have that as well. Not staying updated with your corporate filings or your tax returns. And I'm going to focus more on the annual report that we get to file in the state of Florida. Is due January 1st. It's only $150, I believe, for corporations, $138, I think, for LLCs. It's one simple document. You can actually do it online. It takes 5 minutes. Many businesses fail to do that, and then they get administratively dissolved in September. And then they find out on May 1st that they didn't do it, then the fee, I believe, goes to over $500. So they're just simply, and they actually send you reminders of that, but it's your responsibility to do so. A mistake also that I see regarding taxes, I'm going to focus on payroll taxes in this particular case, is that many business owners, to save money again, decide to do their own payroll taxes, to do their own payroll. And they fail to provide the proper reports, the proper returns to the federal government and to the state government. And in worst cases, they do not withhold the proper taxes for the state and then don't pay them on time, which becomes more of a problem because then you're going to have additional penalties in some cases. So my recommendation here is to use a payroll company. The cost of a payroll company is negligible compared to the services they provide. There are many good companies out there. You can look them up online. They're national companies that have been doing this forever. And they provide all the state reports. They provide the payroll taxes reports. They also pay them for you on your behalf. They give you reports. They withhold the money. It's all done. So that's what I recommend you do, and avoid mistake. And in terms of more of a business tip, my recommendation is to have a separate payroll account that only payroll is paid out of that account. You fund that payroll account every week. You do your payroll from that account. It just keeps it cleaner as opposed to having combined with operations, simply because more money might come out of operations and you might not have enough for payroll. But having a separate payroll account keeps things very organized. And if you need to get audited, it's a very simple way to provide information. Here are the bank statements. Here are the reports. And it's only strictly for payroll. It's more of a business tip. You're not required to do that. It's simply more of a suggestion to do. Another mistake that I see is not protecting your intellectual property, failing to register your brand, logo, or content. It's important to do that. If you spend a lot of time, effort, and money creating your brand, your logo, get it registered. And you can. We also had some attorneys here. We had L.A. Perkins here from her law firm, and also we had John Risby as well, two intellectual property attorneys that can assist you in that matter if you're interested as well. But a mistake from the other side is that you utilizing somebody else's logo or brand for your business. So it's important before you begin to work on a logo or a name or a brand, do the proper research so you don't take somebody else's name and end up being the recipient of a cease and desist letter. I'm going to give you a bonus mistake. And you probably know what I'm going to say. You heard me before. I think it's a mistake for business owners not to have an accountant on call. You should be using, I believe, an accounting service, CPA firm, to help you with your books and records. It's a lot more reliable than if you do it yourself. And frankly, for the cost that you're paying them, you're better off getting an accounting firm to help you get those books and records prepared for you. And also not having an attorney on call. An attorney, especially a business attorney, can help you significantly with those questions that you may have, and it might help you navigate those challenges, legal challenges that you will inevitably face in your business. And I see this, again, I've been doing this 21 years now, and the majority of the prospective clients that I talk to, the mistakes could have been avoided if a conversation with an attorney would have happened before the call came to me. So sometimes being proactive will help you avoid those mistakes. So I hope you enjoyed this episode. If you have any questions about this episode or anything else, you can reach me at richsierra.com. If you want to learn more about my legal services, my website is floridasmallbusinesslegalcenter.com. If we're in Facebook at FSB Legal. If you want to see our YouTube channel, it's youtube.com/@RichardSierra. Remember that Business SOS, 8 common legal mistakes business owners make and how to avoid them. It's available on Amazon, Barnes & Noble. You can ask for any local bookstore as well. Until next week, this is Rich Sierra. Remember that my goal is to help you succeed.